The Nature Conservation Council of New South Wales has just launched world-first legal proceedings in the New South Wales Land Environment Court because we say the New South Wales Government needs to take into consideration climate change when it makes water sharing arrangements across New South Wales.
Our clients are alleging that under the Water Management Act, the ministers were required to not only consider but to act on evidence regarding the likely impacts of climate change on water availability in the catchment.
Now, we don't take this action lightly. We're taking it because the health of the rivers and the ecosystems that depend on them is absolutely critical, not just for nature, but for everybody across New South Wales. We say that the law makes it very clear that nature needs to be taken into consideration as the first priority when determining water sharing arrangements across New South Wales. Now, recently, a plan was made for the Border Rivers area in the north of New South Wales, and we say that the Minister for Water, Melinda Pavey, and the Minister for the Environment, Matt Keane, breached the law when they didn't adequately take climate change into consideration when they made those water sharing arrangements.
The New South Wales Government has in fact invested significant resources into developing quite sophisticated climate modelling, which they could choose to use when they're developing water sharing plans. And in this particular instance, they have chosen not to use it. And our clients are arguing that in fact, they were required to take that into account and rely on it for the purposes of working out how much water ought to be set aside for the environment, taking into account as well the fact that the Border Rivers flows into the Darling-Barker River, and so the less water that's set aside for the environment in the Border Rivers, the less water that the Border Rivers will contribute to the Darling-Barker River, which is further downstream and, as many people will know, was affected by those very serious fish kills a couple of years ago.
Now, taking legal action is a big step and we don't take it lightly. But our rivers here in New South Wales and the ecosystems that depend on them are already in crisis. We are on the front line in New South Wales of the impacts of climate change, and we have to make sure that the consequences of climate change are factored in when we're making water sharing arrangements for the state.
If our clients are successful in this case, they're seeking an order that the water sharing plan be declared invalid and that it be remitted to the ministers to be remade in accordance with the law. The broader impact could possibly be that water sharing plans that are made moving forward will have to take into account climate change data for the purposes of working out, for example, how much water has to be set aside for the environment to maintain the health of the river system and floodplains and sufficient ecological flows for downstream communities in a changing climate, which we know in the Murray-Darling Basin means a climate that is hotter and drier. If we don't maintain and restore indeed the health of our river systems, it will negatively impact on the rights of children and future generations to enjoy and benefit from our river systems in the Murray-Darling Basin.
Now, this isn't just about something that may happen in the future. We've already seen the impacts of climate change on our rivers across New South Wales. We've seen unprecedented droughts, we've seen a decline in rainfall, and we know that system is only going to get worse. Thousands of species depend on the health of our rivers, to say nothing of the communities that depend on those rivers. That's why we've decided to take this world-first action. If you'd like to learn more about what we're doing, go to nature.org.au.